There were forms of corruption involving Supreme Court justices that never became public and historians never found. That's possible. But based exclusively on the public record, it is undeniable that the current court, this Republican-dominated Roberts Court, is the most corrupt in history. And they are corrupt on two fronts. One, extreme financial improprieties and obvious financial conflicts of interest with billionaire litigants whose cases appear before the Supreme Court. But the much graver corruption in the Supreme Court, the corruption that affects the daily lives of all of us, is the corruption of Supreme Court scholarship. Is legal scholarship scholarship if you can just make up stuff? That is the question that I have been privately asking myself for over a year now, and that is the essence of my crisis of faith. Where I once faithfully believed that the Warren Court, followed by the Burger Court, were using the most refined techniques of legal scholarship to deliver to us the true meaning of the Constitution, I now believe the Republican justices on the Supreme Court are just making it up. And they are doing that in a way that scholars cannot possibly do in other areas of scholarship like mathematics or chemistry or biology. And so we have a Supreme Court whose final decision of the year was based on a person who was made up, a person who does not exist. The Republicans on the Supreme Court decided, as Justice Sonia Sotomayor says in her dissent, that, quote, a particular kind of business, though open to the public, has a constitutional right to refuse to serve members of a protected class. The court does so for the first time in its history by issuing this new license to discriminate in a case brought by a company that seeks to deny same-sex couples the full and equal enjoyment of its services. The immediate symbolic effect of the decision is to mark gays and lesbians for second-class status. In this way, the decision itself inflicts a kind of stigmatic harm on top of any harm caused by denials of service. The opinion of the court is quite finally a notice that reads, some services may be denied to same-sex couples. It was just the day before the Supreme Court issued that opinion, thanks to Melissa Grant reporting in the New Republic, that the same-sex couple named in the lawsuit that reached the United States Supreme Court was proven not to exist. That same-sex couple did not even exist. The lawsuit falsely claimed that a same-sex couple named Stuart and Mike wanted to have a website made for their upcoming wedding. The lawsuit included a phone number for the couple, which Melissa Grant called to discover that Stuart has been married to a woman for many years and has a daughter, and had no idea that his first name and phone number appeared in a case before the United States Supreme Court and was used to deny other people their rights. But because the opinion had already been sent to the printer, there was nothing that the Roberts Court was going to do about the fraud perpetrated on the Supreme Court. And if the court is just making stuff up, they obviously don't care about details like the people who are activating the case in front of them actually existing. That same Supreme Court ruled against what it incorrectly believes is Harvard College's admissions policy. Republicans on the Supreme Court showed an unrelenting ignorance about the 387-year history of Harvard admissions policy by insisting that Harvard must stop the practice of admitting any student solely because of the color of the student's skin. Harvard has